Hello, my name is Johanna Weststar. I'm a professor at Western University, which is in London, Ontario, Canada. And I'm presenting today on behalf of myself and my colleague Marie-Josée Legault, who works at TELUC in Montreal in Quebec, also in Canada. And we're talking today about citizenship at work in the digital game industry. And what I'm going to talk about today is forthcoming in a book that we're preparing for Concordia University Press that we're hoping is going to come out in the fall next year. So we know about citizenship in general in terms of the status of being a legally recognized subject of a nation state. And we know as citizens that we have vested rights, privileges, obligations as a citizen. So what happens when we apply that concept to the workplace and we talk about citizenship at work? And this is a concept that emerged in the early Fordist time through the post-World War II compromise that occurred between labor and capital. And it was initially termed industrial citizenship. And so it's a socio-legal concept. It's not at all the psychological concept of organizational citizenship behavior. Rather, this is a more political concept that came from the state's recognition of the unequal power relationship between workers and employers and the need for some sort of work regulation to overcome that asymmetry. So particularly, we had a circumstance where there were lots of arbitrary decision-making by an authority with the power to act unilaterally. So that's the employer had a lot of power in that relationship, matched with really just a complete economic dependency of people, workers, whose only means of survival was to sell their labor power. And to overcome or reconcile that asymmetry, we saw sort of the development of two approaches. One was the legalization of unions and the institutionalization of collective bargaining, which occurred across OECD countries, and also the enactment of social legislation or universal laws, sometimes referred to as the welfare state or the Keynesian state, to provide universal protections in the employment relationship and in other spheres. When we look specifically then at what those two models, what those are two approaches to solve that power asymmetry achieved, we can see that there are four broad categories of gains that characterize citizenship. So if you are a citizen of your workplace, you can expect to or hope to accomplish some of these gains. One is simply a recourse against those arbitrary decisions that occur in workplaces. The second is the protection of policies and programs that will protect workers against economic insecurity and the risks of losing their income. So we think about things like unemployment insurance, protection against skill obsolescence, birth of a child, illness, injury, layoff, retirement. We can think of a social apparatus that protects us in those instances. And those first two, we would say, are a form of passive citizenship. So in that context, employees are really making use of that regulation that stipulates their rights and obligations, but it's already established by the legislative state, and individual workers, individual employees don't have much direct impact in the setting of that legislation. And so these social laws, these universal social laws, can provide remedies against certain managerial decisions. They provide insurance programs against the risk of loss of employment income, et cetera. The next category, the gains 3 and 4 here, are more active forms of citizenship. So we see participation in the local regulation of labor regarding critical issues. And so here we've given a set of critical issues that apply to the game development in particular. And also then number 4 is participation in the broader social regulation of work. So beyond your workplace. And we often think about lobbying. And here it can kind of circle back to number 2, where you may be able to influence the state and then influence the legal regime, et cetera. So as I said, these are forms of active citizenship where the employees, the workers, take direct part in drawing up that regulation, either by negotiating it in a collective agreement, or when you have a representative body like a union, you can have a voice in setting the advocacy policies and priorities for your representing body. And for each of these gains of citizenship, each of these categories, we can think about the subject, the object, and the domain of citizenship. So we can think about who is a citizen and how and where do these rights apply. Because even in political citizenship, we can think of instances where we have citizens and non-citizens, and citizens sometimes of a different class, where we have different access, different rights under the law. And that's no different in the context of citizenship at work either. So what we're really interested in is whether any of what I just said applies in the contemporary workplace. Because the term industrial citizenship, that concept came to being in the Fordist era, when we look at the changing nature of work, when we look at the nature of contemporary project-based knowledge workplaces, can we say that those workers are citizens of their workplaces? And as you may have guessed, we conduct a case study then of digital game development. And we've, Marie-Josée and I really have studied the game industry for some 10 years and have compiled quite a lot of survey evidence and interview data, as well as secondary literature to sort of bring to bear on our case here. And we look at game development as being very prototypical then of a contemporary project-based workplace that operates very much in this sort of financialized economy. And it has quite strong implications for how that work is organized and how workers may come to have a voice to gain that citizenship, a voice in their workplace. So very quickly, because there is never enough time, I'll just go through each of those 4 gains. So the first, recourse against arbitrary decision-making, what we conclude, and we talk about this in a lot more detail in our forthcoming book, is that there's a significant deficit in the development of workplace policies in game studios. So in some studios, there aren't specific workplace policies at all. And also in the ability of game workers to have a say in those important decisions that are integral to their daily work experience. So as a whole, we would say that there is an environment of discretionary decision-making by managers, producers. That's the norm in this space. And that is applied to major human resource management decisions about setting pay, bonuses, benefits, how employees, workers are assigned to projects, how performance is evaluated, how credit is given, etc. There's also a lot of discretion, a lot of gray area in this space that we call voluntary but expected, unlimited, and unpaid overtime, where there are no clear policies, and oftentimes the lack of clarity of those policies allows studios to skirt regulatory rules. A lot of gray area in how non-disclosure agreements and non-compete agreements come into play. Do people have to sign them? Do they not? What are the risks? Will people be pursued if they break these agreements? And as we see recently with experiences in certain studios, there's a lot of discretionary or arbitrary decision-making when it comes to things like sexual harassment and discrimination in these workplaces. So in general, the worker choice in this environment is often simply to quit if they don't like their environment, maybe to sue their employer if they have the means, or to satisfy, right? To just make do with the environment that they have. And then that kind of becomes a reinforcing circle of the norms of that workplace. On the second gain, protection against economic insecurity, we would conclude that the employment relationship in these spaces is very much individually determined and negotiated. And because of that, we can really see a lot of inequities in who can negotiate a good employment deal for themselves and who can make the deal that's offered to them work in their circumstance. And often the ability to negotiate is gendered, it's racialized, and it's also based on social and occupational class. And we see in general that even for the strongest worker, the most prestigious, or the one with the best skills and the best negotiating power, there are still specific exemptions from protective legislation. For instance, overtime pay. We see a lot of employment insecurity in this environment because of the mobility of capital and labor. Really the risk of that mobility falls on the individual worker to maintain a good portfolio, to maintain a strong reputation. That's how you maintain your employment security in this space. And to do that, you really have to buy in then to the cultural norms of high commitment and passion for the work that again sort of drives this vicious cycle. We see big risks from burnout and other health risks that are often really tied to the working time regime. Workers don't have a lot of ability to say no, and they have mixed access to health insurance programs. A lot of that really depends on the strength in individual countries of that sort of welfare state or that social security net. The risks of obsolescence are really put on the shoulders of individual employees. Most of these studios hire on demand. They're looking for somebody who has the skills right then in the moment, and it's up to workers to make sure that they have them. And of course, there are then risks about aging. There are patchy at best retirement savings programs and pension protections within game studios and this population. The pace of work becomes very difficult as you age, and very difficult when you start thinking about having a family. For the third gain, participation in the local regulation of labor, we do see some evidence of labor action, and Marie-Josée and I have written a short article about that. And some of those actions have some real impact, but really they tend to be temporary coalitions where there's an issue, there's a response, and then it goes away. There's not a sort of a consistent form of participation in labor regulation. Because the industry is historically non-union, and though we are seeing unionization creep into the industry, Scandinavia, the UK, France, Korea are some examples. Not all union models are created equally. So unions operate in different ways. The legal scope of union certification and union coverage across countries differs. And that means that the citizenship levels are uneven. The ability for workers to participate in the local rule setting of their work is uneven. And lastly, in terms of the participation in the social regulation of work, we see that game employers, obviously, many of them are multinational conglomerates. The pattern of mergers and acquisitions to create these really big players is ongoing. They have very strong lobbying voices, and they've been very successful because governments, nation states, municipalities are really actively seeking to bring the new economy into their regions. That gives these employers a lot of voice, and these are amplified often through trade and industry associations. What we don't see is that concerted worker voice in the scene. We do see the International Game Developers Association, but acknowledge that the IGDA has a rather tricky relationship in terms of their ability to be a direct advocate or be that representational voice for game developers, because they walk a fine line between balancing the needs and interests of workers and employers. They've had some struggles with that in the past, and their advocacy is not consistent just by the very nature of the structure of their organization. So to conclude on that point, we really see a lack of participation then in terms of bringing the workers' voice, the game developers' voice, the game workers' voice into important policy decisions such as these: the development of tax credit regimes, labor law exemptions, IP, copyright law, rating boards, etc., as well as any voice in the monopoly power of certain players, actors in this scene, such as the big three hardware manufacturers who have a lot of proprietary and restrictive access protocols. We see challenges with digital distribution platforms and how those bring different games to the fore, et cetera. And so there's not a lot of worker voice in that space of the social regulation of work at all. So to conclude, we see significant citizenship gaps then. We would still hold that those 4 pillars, those 4 gains of citizenship are very important for workers, that workers are really entitled to have a voice in the regulation of their workplaces, but we're really not seeing it in the game development space in the video game industry, and by extension, we see extend those gaps then to sort of contemporary project-based knowledge workplaces as a whole. And we find then that the principles of citizenship can't be automatically extended to many of these contemporary workplaces, and so we have considerable representative and democratic gaps in those spaces. Particularly, we find because of the inequities that creates, we see those gaps more so for underrepresented groups such as women, racialized minorities, et cetera, in those spaces, members who are lower down on the occupational hierarchy in the game development space, for instance, testers, et cetera. So that is where we will conclude. These workers are currently fighting to get more voice, more regulation, but it is an uphill battle because the models, the legislative models, don't currently fit their environments. And so there's work to be done to close those citizenship gaps. Thank you.